One case was mentioned in the morning, Your Lordship. The other side is also here. Both the sides were called, Your Lordship, for fixing a date. In second appeal number, first appeal number 101 out of 23.
No, it was not that. It was mentioned that it should be taken up.
Probably I was told, Your Lordship, I don't know. I was told that, Your Lordship.
Who mentioned it? Somebody from your side only?
Yes.
So I do not know.
Because I was told, Your Lordship has called both of us to fix a date.
No, it's a suit for specific performances.
Yes.
और पिटीशन भी फाइल किए हैं कॉस्ट जमा करने के लिए इनके लटेट एग्जीक्यूटिंग कोर्ट बोले हैं 47 को ऑब्जेक्शन एक मीटिंग लेट मी कंप्लीट वो रिजेक्ट हो गया उसके अगेंस्ट में एक पिटीशन फाइल किया कि हम हाई कोर्ट जाएंगे आपको टाइम दिया गया है सिविल रिवीजन फाइल करने के लिए इनका कोई अर्जेंसी भी नहीं
The urgency तो है जो execution has been filed 22nd.
You mentioned the case.
Yes.
Now you say that date 26. Date is always fixed.
No. What I am told by my
I
colleague.
do not know. Somebody mentioned it on your behalf.
Yes.
If you have any communication gap, go and settle with me. Correct? Tell me, next please.
Item 17, first appeal 9 of 2007.
In this case, actually it is
The judgment is covered.
it is covered the analogous cases FA
Where is the
12.
other side?
The other side
It's a
state
covered case.
it's a covered case. The compensation awarded, the rate has been reduced from
Yes.
1200 to 1000.
So it's a
Para
covered case. You
18.
can dispose it of in terms of
Yes,
the
Your Ladyship. It can be
Where is the
disposed
other side? Call him. कौन है other side?
State से है.
बुला के लेके आइए, state को call करिए.
Yes. They just go for court.
Yes, please. Ask him to be here. ये covered cases में कि stay pending? It will be taken up at 3:30 and forward him a copy of this order. Last time the state council was there.
Perhaps, yeah.
Yes, he was there.
Yes, he
कौन थे देखिए तो? Last time who was appearing?
Mr. Naval Kishore Pandey.
हाँ, इनका नाम फ्लैश करो.
Yes.
Okay, Mr. Naval Kishore Pandey.
Out of turn fixed case, item 35, second appeal 192 of 2025.
This is both the courts we lost. I am the defendant. The title suit leadership may have page 42 for our. This is the judgment of Civil Judge Senior Division Court. A grave error has been committed. A very one line fact is sufficient enough to decide the matter. Page 44. This is a matter where it is an admitted position that 1947 the plaintiffs are claiming a settlement in the year 1947 through the Zamindar. And very surprisingly, the Bihar Land Reforms Act itself has created an embargo that any settlement after November 1946 it cannot happen. So this is one submission. Second thing.
No. Under the Bihar Land Reforms Act, you see, if there is a transfer after 1946, it is a deputy commissioner who will
Yes.
who will initiate a proceeding,
Yes.
and then he will decide whether there is an inclusive transfer or not.
Yes.
Or the transfer is for the purposes of defeating the purpose of Land Reforms
Yes.
Act. So he has got the exclusive jurisdiction to do that. Land Reforms Act basically came into force much prior to 1946.
Yes.
So there has been many transfers in the meantime. But it was his exclusive jurisdiction.
So I'm just
Did he
concerning.
initiate a proceeding?
Yes. Thereafter, by this 1947, it got affirmation in the year 1952. So this has given a 1952 settlement was affirmed by the DC concern. Now what happens in this matter is another settlement has been issued in the same set of land in the year 2000. Who are to this defendants? Now
You are the plaintiff?
I am the defendant.
Okay.
So plaintiff filed a suit basing this settlement of 1947 and claiming that the appellant number 1, she happens to be a tenant of that particular premises, and appellant number 2 happens to be the person who got the settlement through the concern office in the year 2000. Now both the appellant number 1 and 2 are wife and husband. Now here they have engraved a case that appellant number 1 stopped paying the rent also. So she is a tenant to me and she has already stopped paying the rent.
Tenant under BBC?
Yes. So this is the first submission. They exhibit 1 only. They have sent a legal notice once that you have to evict the premises since you have stopped the giving the rent. And meanwhile, another suit, another prayer has been made against the appellant number 2. There is a settlement given in the favor of the plaintiff concern, and in the year 1947, which got affirmation in 1950. Now, what happens in this matter is we have challenged that order, and the performer plaintiff in this matter, he chose not to contest because he was a family part of the family concern. Now, against him, the DC has already declined in terms of Bihar Land Reforms Act. This is one in the year 2012.
No, I don't get it. Second appeal can't argue like this.
I'll just indicate.
Proper dates.
I'll just indicate one thing. Giving a brief outline because the facts are so long. I'm just indicating one thing.
You see, if the facts are so long,
And-
you summarize the facts because
Yes.
it can't be called training substantial. But you summarize the facts, you prepare a note to that effect. No,
Let's see, only
you
one thing.
cannot go on and on like this.
I'll just request one thing. In the first appellate stage, we have given that the concerned court has permitted to place the additional evidence, the commissioner's judgment, which favors me, that my settlement is better enough, not the other side, not otherwise. So that additional evidence has not at all taken care of in the first appellate court has said that this matter is pending before the concerned commissioner, despite taking and allowing me to place the additional evidence.
Where is it?
Yes. The affidavit is ready.
Just a second. First. Second appeal, date written statement.
You see page 12, internal page 12, page 185 rather. The civil appellate court has not even recorded this fact. The concerned court itself has taken my additional evidence and exhibited the certified copy of the judgment.
Where is that? Where is that
So
additional
only
evidence?
the affidavit was ready since.
Where is the additional evidence? Where is it mentioned that the additional evidence is taken on record?
That is not mentioned at all. In the month of April itself, it has been taken and the judgment has been passed in the month of December, and still the appellate court is saying it is pending. And the exhibit was marked also. Leadership, the
What
appellate
was the
is.
exhibit number?
That is not mentioned this
It
side.
is not mentioned.
Not mentioned.
You have a copy of that.
Well, if Lordship lets me permit,
Can you give me?
this appellant is having some spine issues, therefore we could not file the supplementary affidavit.
You
And this
must have
is
made it as a substantial question of law.
yes.
Is it there in the substantial?
No, it is not at all.
Then,
This is the order passed.
see, I could understand had you taken this point in the substantial question of law. But you are just placing this order.
Lordship, it is there. This is the order sheet of the concerned trial civil appellate court. It has permitted the very last page, order sheet recorded that it has been marked as an exhibit 1. The type version of the order sheet permitted and the exhibit marked is the very last page itself. And the commissioner favors us.
And with respect to this proceeding, the court says that it is pending.
Yes, page 185. Internal page number 12. It says, it is written
Read it, please.
that.
Read it.
Leadership,
Which portion you say that it is
I find that the settlement order dated SDU in favor of
Page
defendant.
number 185.
Yes. Leadership,
I find from where do I read this?
Well, my apologies. 84 maybe see. It starts at the last paragraph.
Hmm.
On the other hand, from perusal of Exhibit D, it transpires that the land in question was ordered to be settled by CO Maheshpur by the so and so in favor of defendant number 2 in case of the case. Again, when I peruse the Exhibit E, that is order dated Deputy Commissioner RMA case number so and so, I find that settlement order by the SDU settlement case number so and so on the recommendation of CO Maheshpur I find that the settlement order SDO in favor of default number 2 has been set aside. Against that order, learned Deputy Commissioner has been challenged in the court of Honorable Commissioner of Santhal Pargana, and that has been admitted, but no final order has been passed. This is the final order which has been exhibited by the concerned court, taken on record rather. And that has been done in the month of April. The very last page, handwritten order is there also.
Also, learned counsel for the appellant. The learned counsel for the appellant has produced a copy of the order dated 12/3/2024, passed by the learned first appellate court, wherein the final order passed by the learned commissioner in Revenue Miscellaneous Appeal number 45 of 2003-4, dated 4/3/2022, was adduced as additional evidence, and the same was directed to be taken on record. The learned counsel submits that.
That is the order for execution.
The same document was also marked as Exhibit 1 by the learned first appellate court on 18/4/2024.
Judgment delivered December 2022.
He submits that the final judgment by the first appellate court has been delivered
12 December 2020.
on 12/1,
12 December
12/12/2024,
4. 174 is the page.
but the additional evidence has been completely overlooked. He has submitted that, on the contrary, the learned first appellate court records that the proceeding is still pending before the learned commissioner. The council submits that the final order passed by the commissioner in Revenue Miscellaneous Appeal number 45 of 2003-4 has a serious bearing in the matter, and therefore a substantial question of law being framed in this connection. In considering the submissions, this appeal is admitted on the following substantial question of law: whether the learned first appellate court erred in law in ignoring the additional evidence which was placed on record by the order dated 12/3/2024, read with order dated 18/4/2024. And whether on account of non-consideration of such additional evidence, the impugned judgment is coercive. That's all. Issue notice to the respondents for the requisites under speed post. Who are the respondents? They are resident of this place.
These persons. Please are same.
For which requisites under speed post as well as ordinary process be filed within a period of 1 week.
The trial court is proceeding with the execution. It's very difficult to address also because within 2-3 days time the matters in fixed.
It's a time bar.
Let's one IA is there for condition of delay and also the
I will
IA.
not agree with it. I can't agree with it. You should have pointed out at the threshold. You mentioned a matter.
My apologies, because the leadership, we have just prepared.
It's order to recall condition. We can't do anything. In a time barred appeal, we cannot pass an order of stay not acting for the date of
The IA notice may be issued for the IA to short date may be given. The execution code is proceeding, plus obviously there is a
We
judgment.
will proceed in your appeal is time barred. How much is the delay?
200 days, 202 days. She's having a spine issue. Due to that,
IE number 15140 of 2025. Other defects have been removed?
yes, yes. Just, therefore, it is registered.
Issue notice to the respondents in the interlocutory application. Submission खाली लिखा देते हैं, but the submission है वो. Since the appeal is barred by limitation, it is in this court issues notice to the respondents in IE number 15140 of 2025 seeking confirmation of delay in filing the appeal. At this, the learned counsel for the appellant has also submitted that one interlocutory application being IE number 176 of 2026 has been filed with a prayer for stay of proceedings before the executing court, being execution case number 2 of 2025, pending before the court of the civil judge senior division 1 at Pakpur. The notice is directed to be issued also in the interlocutory application. It will be open to the appellant to serve the notice to the respondents through their advocate in the executive and file an affidavit before this court regarding service. Additionally, you take both.
yes,
Since the respondent number 4,
BCS
respondent number 6
Six.
is the Deputy Commissioner Pakpur, no notice need be issued. The notice upon him be served through the office of Learned Advocate General. The counsel for the appellant is directed to serve 2 copies of the memo of appeal along with its enclosure and synopsis in the office of Learned Advocate General within the period of 1 week. Judge?
Next is on execution cases are listed on 21st division. December 3 dates. 21st this month itself. Last listed on 17th and prior to that 10th and 7th. Every
Prior to that, you served them. Post on 11.
deeply.
I think you'll have to file your dusty
That's the
notices
we'll do that.
and then needful can be done. But when you serve the notice to the advocate, ensure that his identity is properly disclosed
Yes.
and it is served in presence of witnesses. And you have to file supplementary affidavit, the original one.
Yes.
Don't just file photocopies. I will not
Fine.
accept it.
Appearance will be.
Deeply.
Yes, counsel is there.
Yes, ladies.
You are there for the state in this case. It's a covered case.
Yes, yes.
I'll dispose it off in
Yes.
terms of the same judge. The learned counsel for the parties are present. They submit that out of the batch cases which were tagged together by order dated once the order is tagged. नहीं ऐसा करिए the learned counsel submits that out of the same land acquisition proceedings numerous land reference cases were instituted and common judgment was passed. Jointly submit that apart from, except the present appeal all other appeals have been disposed of.
Yes.
By common judgment, dated, now I give you a copy.
24/7/2000.
A copy. Dated 24/7
2019.
2019. नहीं, 16th of August 2019.
16th of August, I'm sorry.
16th of August
16th of August
2019. They jointly submit that the present appeal be also disposed of in the same terms. They have also submitted that the cases were tried together and there was common witnesses and evidences in
Yes.
all the cases. Correct? Considering the aforesaid submissions and with the consent of the learned counsel for the parties, this appeal is disposed of in the aforesaid terms. थोड़ा सा formal कर देंगे. ठीक?
Yes.
Para number 18.
Para 18, para 14, 14, 15, 16 is the finding, and then 18 is the last result.
14,
15, 16,
16 is the finding.
I mean considerations, and
Yes.
18 is the finding. I'm sorry. 18 is the finding.
18 is the finding.
Yes.
Okay. This appeal is also allowed to the aforesaid extent.
Yes.
Award to be prepared. इसका soft copy. All substitution is all complete.
Yes, all substitutions are there.
Under the heading for hearing under order 41/11 CPC item 49, second appeal 560 of 2015.
May I please the sound? Leadership may tender a brief notes for leadership's candidates.
You are seeking declaration of adverse possession.
Yes, Your Ladyship. Before commencing, let us point out two things, Your Ladyship. On the last date, that is 17/12/2025, Your Ladyship had been pleased to call for the records, but it appears that records of the title suit have not yet been received. The records of only title appeal have been received.
Seventeen, 12, 25.
Yes.
17. You are done like this.
Yes, sir.
And the advocate on record is absent.
She's there.
SC number 560 of 2015. The counsel for the applicant as well as the learned amicus appointed by this court are present. It has been pointed out that the trial court records have not yet been received. Office to issue express reminder.
Perhaps there's a letter, Your Ladyship, of 17th January 2026 of the Learned Court.
For seeking time for execution. The records are missing. Was sent to the court of learned district for reference. A letter number 5 dated 17 January 2026 has been received from the Court of the Civil Judge Junior Division, Lohartagga, stating that the then office clerk has been directed to trace out the records of the trial court at the earliest. And some more time has been placed. Send the records to this court. Pose this case on 26th of February.
There is quite a one more clarification. On the earlier occasions, notices were issued to the respondents, and from the service report it appears that regarding respondent number 1, who is the private respondent, the notice first time it was received by his nephew and the second time by his wife, and respondent number 2 it has been received in his office. That is what.
Notice is complete.
Notice, in addition, the reason is not there because the appeal
Why
has
the
not been
notice was issued?
that is not coming from the audit. Notices are issued by audit dated 21 April 2017 and again by 25th March 2019.
The learned counsel for the appeal, the learned amicus has also pointed out that notices were issued upon the respondents by order dated 21st of April 2017 and also by order dated
25 March 2019.
25/3/2019, and he submits that the notice has been duly served upon respondent number 1 through his nephew,
First time by his nephew, second time by
and
his wife.
first time by his nephew and second time by his wife. And so far as respondent number 2 is concerned, the notice has been received in his office. He submits that the notice be accepted as valid, considering the submissions, the notice issued upon the respondents is accepted as validly served. Who is respondent number 2?
Respondent number 2 is your initial the DC Lohartagga.
Counsel for the appellant is directed to serve 2 copies of the memo of appeal in the office of the learned advocate general, who shall appoint an appropriate counsel to represent the respondent number 2. आप सर्व कर देंगे उनको, स्टेट को, समझ गए? यू हेल्प कर दीजिए। कोई फॉर्मल नहीं होता पार्टी, सूट में कोई फॉर्मल नहीं होता। आपको इनको सर्व फिर क्यों पार्टी बनाया है? नहीं बनाते पार्टी, डिलीट कर दीजिए। स्टेट इज अ नेसेसरी पार्टी, प्रो फॉर्मा पार्टी नहीं रहता डेप्यूटी कमिश्नर इन केस ऑफ ट्राइबल्स। He is a necessary party and he has got everything to say in the matter. नई पार्टी बनाइएगा उनको तो आपका केस फेल कर जाएगा।
अच्छा, इसमें डेट 26 से पीछे चाहे आगे भी
26 को आप नहीं है तो बताइए, 12 मार्च को कर दो। 12 मार्च। Good to see at least that you have seen on the entire records. हाँ, रिमाइंडर तो रहेगा ही, ठीक है। 12 मार्च का केस, ये नोट है, इसको रखें। Do you think that the records are required for framing substantial?
Your Ladyship, the records may not be required because there are 2 substantial questions of law which are formulated, and for that, if your Ladyship kindly sees the impute judgment, then the records may not be needed for that purpose. As your Ladyship, if I may briefly point out to the issues which may come up for your Ladyship's consideration.
She was not able to advance the liability in the last
Because there is only one fallacy of ladyship. There are 3 suit plots involved in the present case, and out of which both the courts have recorded on the basis of exhibits that in one of the suit plots, the plaintiff side has been in possession for more than 70 years.
double five.
Yes. And regarding that, adverse possession finding has not been, the law has not been properly applied in the facts of the case. So that is one of the glaring perversities.
Okay, let's let the report.
As
Because adverse possession requires many other things.
yes, big
Not
question
just
of
the flux of time may not be sufficient.
other factors. But the point here is, Your Ladyship, the other factors have not yet been tested as against the plea of adverse possession.
So we need to see whether there are foundation pleadings or not.
Yes. Because one of the reasons is that the foundational pleading of the date since when he was in possession is not mentioned. So
Here is mentioned.
here is mentioned
We'll
19.
see that.
Yes.
Let the records come.
Public.
Under heading for final response, item 4, second appeal 293 of 2017.
Yes.
I was praying if you could come day tomorrow at 10:30.
Who is for the respondent? You open it. What is the it's landlord tenant relation.
I am ready, madam, but it will take some time. There are some issues that has to be decided in this case.
The issue has already been raised.
Yes. So, firstly, about the interpretation of the section 11 of the Building Control Act, Jharkhand Building Control Act, and what will prevail, whether the contractual terms will prevail or the Act will prevail. So, there are a lot of judgments on that. The second issue is, and there are sub issues in that.
You see, it is only so far as the relationship of landlord and tenant is concerned. The substantial question of law as to whether you are the tenant, landlord.
There's an additional substantial question of law framed by order number 19. That is the main issue.
You have submitted your synopsis.
I can submit it.
Where is the respondent? They have been appearing on the last date.
Yes, Mr. Vishal Kumar Tiwari perhaps.
Counsel for the applicant is present. Nobody appears on behalf of the respondents. He submits that two substantial questions of law have been framed. One by order dated 25/2020 and the other by order dated 7/10/2025. In absence of the counsel for the respondents, this court is not inclined to hear this case finally today. However, by way of last indictments, the matter is directed to be listed on
As first case, if possible.
first case be date we serve can serve.
Maybe.
As first case, then let a copy of this order be forwarded to the counsel for the respondent. Ms. Priya Sahai was it? Maybe that Mr.
Mr. Vishal Kumar Tiwari was engaged in this matter.
You inform him.
Yes.
इसको सॉफ्ट कॉपी को फॉरवर्ड करें। ये ऑर्डर हम टाइप करा देंगे। जैसे आप जाएंगे ना यहाँ
Great.
रिकॉर्ड आ गया।
Yes, sir.
And your note should come to me by tomorrow.
Yes.
Ask him also. I was looking for the note. If he has prepared it, he should furnish it tomorrow. Day after tomorrow, he should not seek time. I will not grant him. Tell me.
Item 5, second appeal 83 of 2023.
Yes, madam, your case has been taken. Tell me.
Your Lordship, in this case, the question of law framed are whether the property in question is ancestral or not, and whether the relinquishment deed and the gift deed executed is void or voidable, and if voidable, whether it is barred by limitation. The challenge to that is barred by limitation.
You read the substantial question of law, please. There is one additional question also, okay?
Yes, Your Honor, just read
There are initially the questions were framed on
30th November.
yes, so all the questions are to be answered.
Yes.
Where is the respondent? Are you appearing in this case? Yes, get your file. Tell me. Read it.
I'll just give some brief list of dates for my loss appreciation. Your Lordship, Babulal
Call you senior. आप बैठ जाइए फाइल लेके बैठिए और इनका आर्गुमेंट्स ना
we have filed it.
You file yours. Yes, this one, short notes.
Yes, and the list of
This one?
at the back. Yes.
Okay.
List of dates and events that page number 3 is.
Page number 3 contains the list of dates.
Yes.
Yes, please. Yes.
Babulal Ghosh is the grandfather of the appellants and the respondents here. He died in the year 1934 or before that, as would be evident from the deed which was exhibited as Exhibit 1 marked before the lower court. Look at that will show that he was not there in 1934. Surya Narayan Ghosh was the only male issue of Babulal Ghosh. So after the death of Babulal, he inherited the property, and the property is the self-acquired property of Babulal Ghosh. Surya Narayan Ghosh executed 4 gift deeds in favor of his 4 sons on 22/4/1972. The sons were minor at that time. Surya Narayan Ghosh, he died in the year 2nd April
At the
19.
time of gift, they were minor.
Yes.
Who accepted the gift from the deed?
Surya Narayan Ghosh is the father. So to that I will come, Your Lordship, that father, like he being the natural guardian, he can execute a gift in favor of.
He died. Surya Narayan Ghosh died.
In 1992.
Okay. Then
That in 1994, one thing I would like to bring to my last notice that the gift deed executed is in respect of some other portion of land, and the relinquishment deed is in respect of some other portion of land.
okay, we'll take it.
Yes. On 24th August 1994, the plaintiffs and defendant number 5 and 6 had voluntarily
The
executed
appellants before this court is the defendant.
yes, the defendant before the lower court, the sons.
Okay. The plaintiff and defendant number 5 and 6.
Yes, they are the sisters.
5 and 6 are the sisters.
Yes, the plaintiff is also the sister of appellant. The 5 and 6, 6 and 7.
Yes, please.
I'll just giving the date. Thereafter, I will come to the gift deed and the relinquishment
Yes.
deed. On 14/9/94, the plaintiff Shanti Ghosh, she executed a cancellation deed before the authority. Thereafter, in 2005, the plaintiff filed a suit seeking the following relief. First one is decree declaring the suit properties are ancestral properties of the plaintiffs and defendants. a preliminary decree of partitions declaring 1/8 share to the plaintiffs and other defendants. Production of gift deed number executed by the father in favor of defendants. It be declared that the deed of relinquishment executed by plaintiffs and his sisters in favor of defendants 1 to 4 by registration deed number so and so is void has got no force in eye of law and binding upon the plaintiff. Then again on 15 February 2008, she got the plaint amended and sought the declaration of the gift deed as null and void. Thereafter, after hearing the parties and all, on 21st March 2018, the Court of Civil Judge, Senior Division, he passed the order declaring the gift deed and the relinquishment deed as void, and also that on the ground that the property in the question is ancestral property. And
Just a moment.
yes,
Declare the gift deed as null and void and void ab initio on the ground that the property in question is ancestral property.
and as the father has not taken the since it's ancestral property, the consent of the co-partners, that is the son, were not taken, so it is void.
What about the relinquishment?
That also the court has held that since it is ancestral property and the consideration is also not mentioned, so it being ancestral property, the daughters cannot be deprived of their right in the
But
property.
they had executed the relinquishment.
Yes, they have. There is no doubt about that.
Then how does it become, and where is the question of any consideration in relinquishment deed?
That is what.
Relinquishment deed will not have any consideration.
That is what.
Then
Then
these are the
again, in
entire
civil
facts.
appeal, the court has.
Now let us see these facts in the light of the substantial question of law which has been.
Yes,
The first one,
the ancestral property.
whether both the courts. And what about the additional question of law?
That was framed on 18/12/2025.
So you want to say that the challenge was barred by limitation?
Yes, and it is a valid deed, Your Lordship. I'll come to that, Your Lordship. The result of the gift deed and the relinquishment deed can be seen that it is a valid deed, registered deed, Your Lordship. All the requirements of a deed is complete.
You see, so far as the gift deeds are concerned, they have been held to be void for the only reason that it was the ancestral property, and for no other reason.
Yes, and
Is that the only reason for declaring the other reasons are also there?
Your Lordship will come to the findings of the
Yes, we'll see the findings. The finding of the appellate court should be sufficient, or we need to see the trial court's finding
No,
also?
trial court is the elaborate judgment. That is more elaborate. My lord may kindly see first trial court.
We shall see that.
So, I should come to page number 12, internal page 12 of the trial court's order.
You have given him your written note? You have given him then your written note?
No,
You please provide it. Because if there is any error, that can be taken care of. You have a copy? You have your copy?
yes,
Page 12.
yes. The issues are framed as page number 10, and the court has directly come to issue number 8.
These issues are also quoted in the appellate court's judgment or not?
The appellate court has also framed 2 issues in Lordship.
You must have. The limitation and these two things, they are framed.
appellate court.
Paragraph 5 of the appellate court judgment is in English, which deals with the issues, which has referred to the issues.
Of the trial.
Yeah,
Yes.
so we can just refer to that, it will be easy. Internal, running page 19.
Yes. Are we whole or the only
No, you just, which all are the issues according to you
yes,
would be
whether
relevant?
I'll come to issue number 8.
Issue number 8 is relevant. Okay.
It talks about the gift.
Then issue number 9 is relevant,
Yes.
and issue number 4 is relevant.
Yes. But in this case, no issue was framed with regard to the nature of the property, whether it is ancestral or
No, issue number 7 is there, whether there is a unity of title or and unity of possession. I think this issue would cover whether it is an ancestral property or not. Right? This issue will cover
Yes.
the nature of property. So you have issue number 4, 7, 8 and 9.
Yes.
Correct?
Yes.
इसके अलावा कोई issue, Mr. Sharma?
So
Is
far
there any other issue which we need to see? You come to running page 19.
My lord has framed some substantial questions.
I have framed it, so I just want to know, so far as the judgment is concerned, only issue number 4, 7, 8 and 9 should be sufficient, or you want to place some more issues, considering the substantial question of law? आपके पास नहीं है substantial question of law? है तो देख लीजिए, इसके अलावा हमको नहीं लगता है कोई issue is relevant. Print चाहिए तो दे देते हैं.
Yeah, I agree.
Issue number 8 and 9, what everything will be decided.
8 and 9. No, issue number 1, whether without framing any issue, whether it was a ancestral property or not, will be governed only by issue number 7, whether there is any unity of title and unity of possession.
One thing I would like to point out, so far as this received lawsuit which has been framed by this court, the parties are on this point they are on the same page.
We'll see that. We'll see that. My small question was, is there any other issue which you think is relevant to decide whatever has been framed? 4, 7, 8 and 9. Yes, madam.
Page
Continue.
19.
Let us see each one.
Not here. Page 19.
You come to page number 12. You please read it. Yes, madam. Read it. Issue number 8.
Yes, that is with regard to the gift deed.
Yes. Let us see what is the finding with regard to issue number 7 first.
Ten is also relevant. Issue number 10.
The trial would have started with issue number 8, thereafter 9 and 10.
Issue
Yes,
number
it is
10.
at page
Issue number 10 is
33.
relevant.
That is a consequential issue. Issue number 7. What is the finding on issue number 7?
Please come to page number 33.
10 also is relevant but in view because we are whether we are entitled for the relief granted or not. That is very important.
Page number?
33, then, internal page. Running page 66.
Running page?
66.
66. Yes, please. Issue number 7. Yes, please continue.
वादी का अभिवचन संक्षेप में यह है कि वादी एवं प्रतिवादी गण आपस में सगे भाई हैं और हिंदू विधि की मिताक्षरा शाखा से शासित होते हैं। वादी एवं प्रतिवादी गण अपने दादा पिता एवं माँ की मृत्यु के बाद संपत्ति उत्तराधिकार में प्राप्त किया और जिस पर संयुक्त रूप से दखलकार है। प्रतिवादी संख्या 1 से 4 ने अपने पिता से बाद भूमि में से कुछ भूमि का दान पत्र निष्पादित करा लिया था, जो कि शून्य दस्तावेज है। इससे संपत्ति का अंतरण नहीं हुआ तथा प्रतिवादी संख्या 1 से 4 ने वादी तथा प्रतिवादी संख्या 6 एवं 7 को विश्वास में लेकर पिता द्वारा दान में दी गई संपत्ति का दावीनामा लिखाने के स्थान पर दादा बाबूलाल घोष के नाम की जमीन का कपटपूर्ण तरीके से विलेख निष्पादित करा लिया, जिसे वादी द्वारा 14 दिन बाद पंजीकृत विलेख द्वारा रद्द कर दिया है। इसलिए वाद पत्र में वर्णित संपत्ति पर वादी एवं प्रतिवादी का स्वत्व एवं कब्जा की एकता है। प्रतिवादी संख्या 1 से 4 एवं 6 व 7 का लिखित कथन संयुक्त रूप से संक्षेप में यह है कि प्रतिवादी संख्या 1 से 4 के पिता सूर्य नारायण घोष ने प्रतिवादी संख्या 1 से 4 के पक्ष में पंजीकृत दानपत्र संख्या 251 और दिनांक 22/4/72 द्वारा कितने जमीन भूमि दान द्वारा अंतरित कर दी गई है, और वादी एवं प्रतिवादी संख्या 5 एवं 6 ने शेष धूर जमीन पंजीकृत नदावीनामा से प्रतिवादी संख्या 1 से 4 के पक्ष में निष्पादित कर दिया है। इस प्रकार वादी को बंटवारे में प्राप्त करने के लिए कोई संपत्ति शेष नहीं बची है, और प्रतिवादी संख्या 1 से 4 के पिता द्वारा निष्पादित दान पत्र वैध दस्तावेज है, जिनके आधार पर उक्त चारों भाई दान में प्राप्त संपत्ति पर संयुक्त रूप से भोग दखल कर सरकार को राजस्व भुगतान कर रसीद प्राप्त कर रहे हैं, और वादी एवं प्रतिवादी संख्या 5 एवं 6 द्वारा प्रतिवादी संख्या 1 से 4 के पक्ष में निष्पादित नदावीनामा बिना कपट के स्वेच्छा से बिना किसी दबाव के निष्पादित किया है। इसलिए वाद भूमि में वादी एवं प्रतिवादी संख्या 5 एवं 6 का कोई अंश नहीं बचा है, तथा वादी एवं प्रतिवादी संख्या 5 एवं 6 को उनके अंश के बदले नगद धन एवं सोना दे दिया गया है, जो उन्होंने अपने नदावीनामा में स्वीकार किया है। इस प्रकार वादी एवं प्रतिवादीगण की वाद भूमि पर स्वत्व एवं कब्जा की एकता नहीं है। वादी एवं प्रतिवादीगण इस बिंदु पर सहमत है कि इनके दादा बाबूलाल घोष एवं पिता सूर्य नारायण घोष तथा अहिल्या देवी माँ थे, जिनकी मृत्यु हो गई है, और वादी एवं प्रतिवादीगण सगे भाई बहन हैं, और यह हिंदू विधि की मिताक्षरा विचारधारा से शासित होते हैं, और बाद भूमि खतियान में बाबूलाल घोष के नाम से दर्ज है, और बाद भूमि के खतियान की सच्ची प्रमाणित प्रतिलिपि प्रदर्श तक प्रस्तुत की है, जिसमें खतियानी रैयत बाबूलाल घोष है। पूर्व विवादक में सूर्य नारायण घोष द्वारा अपने पुत्र प्रतिवादी संख्या 1 से 4 के पक्ष में निष्पादित पंजीकृत दान पत्र प्रदर्श 3A से 3D को प्रारंभतः शून्य एवं घोषित किया जा चुका है, और प्रदर्श 3 पंजीकृत नदावीनामा विलेख संख्या 200 को भी शून्य घोषित किया जा चुका है, और बाद भूमि में वर्णित संपत्ति का अंतरण नहीं हुआ है, तथा वादी तथा प्रतिवादी संख्या 5 एवं 6 को बाद भूमि में उसके अंश के बदले सोना एवं नकद धनराशि देना प्रतिवादी ने अपने अभिवचन में वर्णित किया, लेकिन कितना नकद धनराशि एवं सोना कब दिया गया है अपने अभिवचन एवं साक्ष्य में वर्णित नहीं किया है, और वादी उनकी बहन प्रतिवादी संख्या 5, 6, 7 का जन्म वर्ष 1956 के बाद होने से यह अपनी पैतृक संपत्ति में उनका द्वारा अंश प्राप्त करने से वंचित नहीं हुई है, बल्कि उक्त अधिनियम के द्वारा महिला को सीमित अधिकार के स्थान पर पूर्ण अधिकार प्रदान किया गया है, और वर्ष 2005 हिंदू उत्तराधिकार अधिनियम द्वारा पुत्र एवं पुत्रियों को अपने माता पिता की संपत्ति में समान अधिकार प्रदान किया गया है, तथा माननीय उच्चतम न्यायालय की व्यवस्था सिविल अपील नंबर 100 और सुमन सूत्र एवं अन्य विनाम अमर एवं अन्य में अपनी निर्धारित किया है कि पुत्री की शादी में सोना एवं धन प्रदान करने से उसका अंश अपने माता पिता की संपत्ति में रिलिक्विश नहीं हो जाता, और पुत्री भी पुत्र की तरह अपने जन्म से ही सहदायी सदस्य होगी, और अपने माता पिता की संपत्ति में पुत्र के बराबर अंश एवं उत्तरदायित्व प्राप्त करेगी। इस प्रकार वादी एवं प्रतिवादी जन हत्याली रैयत के पुत्र बाबूलाल के पुत्र सूर्य नारायण घोष के पुत्र एवं पुत्री होने के कारण वाद संपत्ति में बराबर अंश प्राप्त करेंगे और वादी एवं प्रतिवादी जन द्वारा वाद संपत्ति के किसी भी अंश का अंतरण नहीं किया है। इसलिए वाद संपत्ति पर वादी एवं प्रतिवादी जन की स्वत्व एवं कब्जा की एकता है। इस विवादक को साबित करने का भार वादी पर है, जो साबित करने में सफल रहा है। इसलिए यह विवादक शादी के पक्ष में एवं प्रतिवादी जन के विरुद्ध निर्णय किया जाता है। Your Lordship, I just want to say that daughters, they have right. There is no doubt about it. They have the right. That is how they relinquished their right in the share. Unless they had any right, they would not have. They could not.
But the court records that there is unity of title and unity
There
of
is no
possession.
unity of title. For unity of title, Your Lordship, you will have to see how the property has travelled down. Like Babulal Ghosh is the grandfather. He died in the year 1934.
That's right.
Surya Narayan Ghosh was the only male issue, and the law of succession was according to the Mitakshara law. So it devolved on him. He became the absolute owner of the property. They were not existing at that time, though there was no joint family existing in 1934. They were born after, one was born before 1956 and other were born after 1956. So
I
the
just want to
only,
know,
yes,
what is the date of the deeds?
1972.
1972. By this time, everybody was born.
Yes, everyone was born.
Everyone was born. But
Yes.
prior to deed, everybody was born.
Yes.
Right?
Yes.
So, upon birth of daughters in the family,
Yes.
did they acquire any right over the property by virtue of inheritance?
Yes. Unless, till the father is alive, they did not have any right over that property, which Surya Narayan Ghosh, the father, inherited from his father Babulal Ghosh. So only they have the right, but at the point when Surya Narayan Ghosh, he is alive, they did not have any right.
How do you say this? Because do you want to say that in the property acquired by grandfather,
That
the
is the
grandchildren, they do not acquire any right by birth?
No, no. They acquire only when it becomes an ancestral property and only when it
When
travels
does-
down to the third generation, for the fourth
Which
generation.
provision of Hindu Succession Act would you rely on?
This is as per the Honorable Supreme Court, relying on various smritis and sastic texts and some Hindu laws.
So as long as even when third generation is born, the property at the hand of the father, which was self-acquired property of the grandfather, remained his exclusive property.
Yes, that because it defaulted on him in way back in 1934, he became the absolute owner of the property. Even after coming of Hindu Succession Act 1956, as per Section 8, the property which the father will get from his father, like from the grandfather, it will be his own property, and the grandson and the granddaughter will have no right, or the sons, even the
relying
sons.
upon certain judgments. When did this Surya Narayan Ghosh die?
He died in 1992.
1992.
But the question here would be whether it is an ancestral property. Only when it is an ancestral property, the father was required to take the consent of the other co-partner. But he got inherited the property way back in 1934, which was the self-acquired property of his father Babulal Ghosh. So he became the absolute owner of the property. He was the only male issue.
When will this particular property acquire the status of a co-partnership property?
When it travels down to the third generation, the
Third
acquirer
generation would be the father and
the father, then thereafter the sons, grandsons, and then after
third
great
generation is
grandsons.
to be counted from the father, or it is to be counted from the grandfather?
It will be counted from the grandfather.
If it is to be counted from grandfather, then
Yes.
these children, they constituted the third generation.
Yes.
If they constitute the third generation,
No.
then the property will acquire the status of a joint family property, that is the ancestral property.
No. Your Lordship, I kindly appreciate that.
Mr.
Sorry, Narayan
Sharma,
Ghosh.
we have decided one judgment. आप क्यों नहीं हमको देते हैं? कहाँ है?
वो judgment already मिला है. But that fact is not here. That
Your
is
Lordship,
No, that you see the property. Her argument is the property is of grandfather, and after his death, it devolved upon his sole surviving son. Now, when does this property acquire the status of a joint family property or ancestral
Yes.
property?
Let her argue.
वो judgment citation
हम दे
दे
दें.
दिया.
देवनंदन गोप का जजमेंट है.
हाँ?
देवनंदन गोप का जजमेंट है.
देवनंदन को फाइनल हो गया कि अपील में गए हैं?
I am not.
देवनंदन को कब डिसाइड किया? कुछ केस का नंबर याद है?
हाँ, yeah. 399 of 2016.
399 of 2016.
Read with 402 of 2016.
402 of 2016. ठीक है. इसका सॉफ्ट कॉपी को टाइप करेंगे. काफी लंबा जजमेंट.
But that issue was entirely different.
We'll see that. We'll see that.
Here the issue
relying for
is here the issue.
You
is
see the
entirely
point
different.
number 1 which has been framed way back as on 30/11/2023.
Yes.
Whether both the court below have erred in recording a finding about the nature of property as ancestors' property without claiming any issue in this.
Yes, वो point पर भी हजूर हम दिखाएंगे इसमें. इसको दिखाएंगे when a court can consider अगर कोई issue अगर specific नहीं भी है, but if the parties are alive and entire
Not
arguments.
only the parties are alive, the fact is also very clear, and there is no doubt on this.
No doubt on it.
That the property was a self-acquired property of
Babulal
Ghosh.
And to let her argue, then I will argue. If my lord will go through the gift deed, which is under question, my lord will find that very recital says that it is the ancestral. How are they denying all these things? I at least cannot understand. When the document on which whereby you want your right, if the document itself says so,
They consider the property
yes,
actually
says so.
the
It
general.
says so.
We'll see that.
The general view is that the property is inherited
Becomes-
from grandfather
it
property
becomes
or
ancestral
Catholic
property by
sampati.
your-
Yes.
It is a
We'll
point.
see that. We'll see that. But this is something very important. What will be the nature of property? In order to ensure that the grandchildren has some rights,
There are judgments of.
you are relying upon some judgments.
Yes, also.
You just give me that judgment.
This is
There are judgments. Some
We'll see
judgments. I will show the
that is
Nita
yes,
Sharma
yes.
case
I have
also.
mentioned that
Nita
in my brief notes also, but again I am giving this is 2000.
You have got a copy?
No, I have this one. I have given the
It is
list of
2000?
cases.
2000?
22, 11, Supreme Court cases 520.
520. ये दीजिए हमको.
Arunachala
2022 11 SCC 520. Yes, continue, ma'am, please.
So, from this judgment, I am read to show that when the properties become
Para number?
Your Lordship, may kindly come to page number 20 of this. Para number
ये नहीं आया है.
54. It's going on.
Para.
Para number 54.
नहीं मंगाइए ना क्या कर?
जी जी
How many pages are this judgment?
It is from page 1 to 29. This case, the law is like extensively surveyed and clarified.
Yes, yes.
With regard to the daughter's right also. This is 54 at page
आपको क्या
539.
डिस्कस कर रहे हैं?
539.
किताब है तो दीजिए, नहीं है तो मत दीजिए. They have given you the list. Why have you not brought it?
Sorry, this is my. This is
You gave me a
539.
print.
539. I had given you one copy.
Yes. Ahmed Ali, you can just so which you read it the relevant portion. Please.
After referring to various laws, the Supreme Court coming to the relevant. Again, it is not pretended that on the death of the acquirer of separate property, the separately acquired property falls into the common stock and passes like ancestral property. On the contrary, it is admitted that if the acquirer leaves male issue, it will descend as separate property to the issue down to the third generation. Although therefore where there is male issue, the family property and the separate property would not descend to different persons, they would descend in a different consequences. The sons taking their father's shares in the ancestral property subject to all rights of the co-partner in that property and itself acquired property free from those rights. The course of succession would not be the same for the family and the separate state, and it is clear therefore that according to Hindu law there need not be unity of heirs. In this case, basically, it was the court was seeing what is the right of the woman when father dies, intestate, leaving behind no male issue. When there are male issues, then the daughter did not acquire any right. Prior to yes, and thereafter, if there is no male issue, then the daughter will
Para
have.
number 68.
Yes.
Right of a widow or daughter to inherit the estate. Have you got it, Mr.
Yes.
Sharma? If a property of a male Hindu dying intestate is a self-acquired property or obtained in partition of a co-partnership or a family property, the same would devolve by inheritance and not by survivorship. And the daughter of such a male Hindu would be entitled to inherit such property in preference to other collaterals.
Yes, other collaterals. Like if there were no male issue, then the daughter had the right to acquire the property. There are other judgments also of Supreme Court only. I have the civil appeal number in that case. In that case, also referring to Mullah's Hindu law.
Okay. Which is that civil appeal number?
I've given appeal number. So,
ये judgment का हमको प्रिंट चाहिए होगा हमारे साले का. In this case, the High Court had not dealt with the substantial question of law and ultimately it was remanded. It does not lay down any binding precedent. It may have referred to many things, but it is not a binding precedent.
no, I'm not saying that it is a binding precedent, but what the court has said about the co-partnership property and the ancestral property.
You want to reiterate those submissions.
There are other judgments also. So I have mentioned in my list of dates and also.
But from that point, the judgment is on point that whether the property will devolve by survivorship or by the inheritance.
So in this case,
It's on a different issue.
no, but the question is whether the property inherited by will become his own separate property.
But Mr. Sharma, the point is whether it was his own separate property which he could have gifted.
Yes.
That is the point. If
I
he had the right to gift,
yes.
the matter ends. He can gift it to a stranger
Matter
also.
does not end there itself also. Because not so far as the validity of a gift is concerned, it does not.
You see, if you question the validity of a gift, then you have to fall within the period of limitation.
No, that I will also show. That if suppose the document itself may not.
Let me complete all this. So far as the first substantial question of law is concerned, your contention is that it is not an ancestral property. And no such issue was framed also to that effect. Whether it is an ancestral property or it will devolve by survivorship or it will devolve by inheritance as per the Succession Act. So those issues were also not framed.
Those issues were not framed, but the fact is there that Babulal Ghosh, he died in there, and he was the Surya Narayan Ghosh, the father was the only male
That's
issue, or he acquired the property as
Okay.
a
What is the
separate
finding of the
property.
learned first appellate court on this point?
Yes,
Issue number 7, finding of first appellate.
yes, it is at page number 30, I believe. Starts at page number, internal page 19, running page 29.
Yes, and
The third finding of the first. In the light, I'll read. In the light of the above mentioned in the light of the above mentioned discussion and the judgment of the Honorable Apex Court, and after going through the gift deed, Exhibit 3A2.
you read it from the top. In another judgment.
In another judgment, which has also been relied upon by the learned trial court, titled as Timaya and others versus Ningama and another, reputed in so and so, it has been held by Honorable Apex Court that Karta may dispose of ancestral property only when disposition is of a reasonable portion and is for a recognized pious purpose. The court has dealt with ancestral property. I
That's
say
right.
that it is not an ancestral property.
That's right.
Permission is taken of other persons having an interest in the property, whether in court or otherwise. In the same judgment, the Honorable Court has further held, relying upon another judgment of Burama Bharat Chanbasappa Deshmukh versus Malappa Chanbasappa, that a managing member may alienate joint family property in 3 situations, namely legal necessity, benefit of the state, or with consent of all the co-partners of the family. That is with respect to the ancestral property. In the light of the above mentioned discussion and the judgment of the Honorable Apex Court, and after going through the gift deed 3823 exhibit, which has been executed by the father of the party, who is also the Karta, it is clear that there is no mention in the gift deed that for which pious purpose or legal necessity the ancestral property is being gifted to other co-partners. The only factor mentioned in the gift deed is that the property is being gifted due to love and affection and being pleased with the service. Admittedly, at the time of the execution of the gift deed, the sons who are the appellants herein were minor and were also unable to render any service. The London trial court has rightly held that the gift deeds are void ab initio on this count, even if it is supposed that the minor sons, after attaining the majority, accepted the gift deed and enjoys the property which is reflected from the revenue receipts exhibit.
The entire judgment is based on the assumption that it is an ancestral property.
So basically, with regard to that only, if we come to that it is not an ancestral property, the father had all the right of self-disposition, and the daughter had the right respect of other remaining properties. That is how they had relinquished their rights.
That's right. So this issue is over now. And then next
There
one
are,
is
I have mentioned some other judgments also in my brief notes and synopsis regarding ancestral property and all.
which all judgments you have to just mention. One is this Arunachala. There is
Commissioner of Wealth Tax, and that will deal with Section 8 also after coming of the. In this case, Yudhishthir versus Ashok Kumar reported in so and so. Actually, this judgment, all judgments are
3
relied
degrees,
on.
basically on 3 degrees.
Yes, then only it will become ancestral property. Then I have given one judgment with regard to the gifting of property by parents to minor. And thus
Gift need not be for legal necessity.
Yes, because
For gifting, there is no need of any legal necessity. For gifting, there is no need of any legal necessity. For sale, there is a need for legal necessity.
and there is no need for any consideration
There
of
is no question of any consideration.
Yes.
Acceptance section start by
acceptance is must.
That
That
is
is
acceptance.
yes, that is
And
the
the trial court
I
has
will-
taken into consideration that they were all minors and there could have been no issue for the rendering of service to the father.
It's not that you say gift need not be for rendering service.
I mean, that what he has.
But gift need not be.
Consideration can be
That's
satisfied to render service.
that for
Legal necessity, I do agree. That,
Now, you see, now this is done. You address on the point of limitation. It is changing in the matter.
so
Which is that additional substantial question of law was framed,
Yes.
whether the suit
the
was barred by
first,
it.
yeah, that your lordship, the question of law was from that whether it is void or voidable.
Yes.
So a look at the relinquishment deed and the gift deed will show that it is a valid gift deed, your lordship, being complete in all respect. So reading of that will make it clear, your lordship.
Exhibit number
Yes, exhibit 3A to 3D is the gift deed.
3A to 3D.
Yes.
Relinquishment deed.
That is 4D.
It's in Bangla. It is very surprising that they are governed by Mitaksharas.
Yes, but
Bengalis are generally governed by
they are
Deyaparas.
actually not Bengali. They might be speaking Bengali, but
Okay.
they are not Bengali.
Surya Narayan Ghosh.
This is
Anyway, they have taken a plea that they are governed by Mitaksharas, so we don't need to bother about it.
The release date is exhibit 4D, your lordship.
Exhibit 3D है, इसके बाद exhibit 3E है. Deed of cancellation. You are referring to relinquishment deed first?
Your lordship, whatever like it is
No, whatever you want to like.
relinquishment deed.
Their signature, etc., is not disputed.
No.
Execution
Everyone has
is not
witnesses
disputed.
have also signed, and your lordship may kindly come like the husband of the plaintiff and one of the sisters have also signed, the mother had also signed.
So it is
And
duly
the
executed.
Yes, duly executed.
It is not in dispute that it has been executed.
Ah,
Because there is also a cancellation of relinquishment deed. That
So
itself
they-
goes to show that
they
it
were
was
aware.
executed.
Yes, and they were aware of this fact. So in way back in 94. So the court below only on the ground that it is not mentioned that on what consideration and what are the amount of consideration given the relinquishment deed was executed. So they cannot be deprived of their ancestral property. So the question comes back to ancestral property. And here like everything was the witnesses were also examined, and in fact, they say that they were not aware of the gift deed executed by the father, but the deposition by the sisters and the husband of the plaintiff would show that they were aware of the gift deed. They say that the brothers, the defendants, they told them that they have to execute the relinquishment deed in against the land which is gifted to them. But there is no earthly reason to get relinquishment deed of the land which is already their own land, which is gifted to them, your lordship. So this plea of the respondent, the plaintiff, that they were misrepresented.
This particular relinquishment deed
Yes.
has been executed by who? The
By all the three sisters.
plaintiff and the defendant number 4 to 7.
No, not 4 to 4 is the brother.
5 to 7.
This it is executed by defendant number, the plaintiff and defendant number. That is 5 and 6.
Defendant number 5.
They are sisters, Sandhya Rani and Veera Kumari Ghosh. The mother and the husband also of these sisters, they have signed the, and they have said that
5 and 6.
yes, they are the sisters, Sandhya Rani Ghosh and Veera Kumari Ghosh. So the only ground taken by them that they misrepresented the appellants or the defendant, they misrepresented. They told the sisters that they have to execute the relinquishment deed against the land which is already gifted to them. But there is no earthly reason to get a relinquishment deed against land which is already the land of the
Sisters.
no, the
Brothers.
land of the brothers, which was gifted to them by them. So this can show that they want the land. That is why they want the cancellation. Maybe because of some extraneous reasons. Otherwise, the the relinquishment deed is complete in all respects. And it is also, it can be without consideration, with or without considerations. And even if it is assumed to be voidable, then there is it is required to be set aside by a competent court. And for that, I am relying on the judgment of Supreme Court.
And with respect to the gift deed,
Yes, that is also complete in all respects. The executant have also signed. The witnesses they are required to sign. They have also signed, and it can be a gift can be in favor of minor also. For that, I am relying on the judgment of Supreme Court in case of this K. Kamalam versus. Yes, K. Balakrishnan versus K. Kamala.
what are the basic ingredients of a gift deed, even if it is a registered document? It is governed by which section?
The Transfer of Property
Which
Act,
section?
it defines, I'll just come
Transfer
to that,
of
it is
property.
given in the judgment itself. I'll just come to that. In this case, the only I'll just, in this case, Balakrishnan versus K. Kamla, it was decided in 2003. The only substantial question of law involved in this appeal is whether the appellant, who was minor on the date of execution of the gift deed, can be held to have legally accepted the property in suit gifted to him, and the said gift deed was irrevocable.
This is AIR to the equivalent SCCS.
Yes, I'll just give the equivalent is 2004 volume 1 SCC 581. I have a copy if you're not
Please give it. 581.
Yes. Footmaster. Volume 1 SCC 581. 581.
Admittedly, these children were minor at that point of time, all of them.
Yes. Your Lordship may come to page number 3 last. I will start reading from page number 3 last. Para.
If everything is quoted, all these provisions are quoted.
Yes,
If we come to page number 8, as seen above, in the case of a minor donee,
At page number gift is defined under section 122 of the Transfer of Property Act.
you can come to page number 8.
Then all other sections are also dealt by the Honorable Supreme Court. Yes, I'll go to page number.
Page number 8, bottom.
Yes. Last para.
Last para, as seen above.
In the case of a minor donee receiving a gift from her parents, no express acceptance can be expected in this possible. An acceptance can be implied even by mere silence or such conduct of the minor donee and his other natural guardian as not to indicate any disapproval or repudiation of it. In our considered opinion, therefore, the trial court were wrong in coming to the conclusion that there was no valid acceptance of the gift by the minor donee. Consequently, conclusion has to follow that the gift having been duly accepted in law and thus being complete, it was irrevocable under Section 126 of the Transfer of Property Act. Section 126 prohibits revocation of a validly executed gift except in circumstances mentioned therein. The gift was executed in 45, it remained in force for about 25 years, during which time the donee had a 10 majority and had not repudiated the same. It was therefore not competent for the donor to have cancelled the gift and executed a will in relation to the property.
That's the biggest line on this. So this is on the revocation of gift
And
and the relinquishment.
And I'll come that even if it is, I'm not admitting, but even if it is assumed to be voidable, then in that case also it is required to be set aside by a competent court. So the relinquishment deed also.
It
For
does
that
not
also,
become void acquisition.
yes.
According to you, it is not void acquisition. And therefore the suit was barred by
Yes,
it.
yes. For that also I'm relying on a judgment of Honorable Supreme Court, Your Worship. That is. Yes, it's AIR 2022 Supreme Court 5058.
This Subhidi Devi.
Yes.
Is any equivalent of this?
Only, I don't
Anyway,
have it's online given, Your Worship. AIR online 2022 SC 453.
So that should be sufficient. If it is voidable, then it has to be filed within limitation.
Yes.
If it is void ab initio, then under such circumstances it can be ignored
Yes.
at any point of time.
And for what are void and voidable deeds and instruments, that for that also I am relying on the judgment that if the legal effect of something which cannot be taken away, that it is voidable and not void, unless it is set aside. If
That's all.
Your Lordship wants, I can give the citation of that, please, for void and voidable.
Yes, you can give one citation, but the law is well settled on
Yes.
this. Yes. आप कौन कौन आर्ग्यू करेंगे?
This matter,
Like tomorrow.
I have to clarify certain things. First of all, that whether if at all this issue is to be considered, that it is a ancestral property or it is a self-acquired property, whether it is an issue of law or it is a question of fact, it is to be also adjusted.
Certainly, it has to be seen.
Adjust. And whether or not question of fact, which can be raised the way they are raised, that is the another issue that I would like to answer on this issue.
Yes.
Second point, Your Worship, I will show it from the written statement and read also, that nowhere it was at all disputed that
I want to know, is there any finding that it was a self-acquired property of grandfather?
no,
No,
the,
it is-
the reason is, my lord, may kindly see order 14. Your Lordship, may kindly see order 14.
Late.
Audio.
My lord, may kindly see framing of issues. Issue arise, did my lord find? Issue arise when a material proposition of fact or law is formed by one party and decided by another. I am reading one. Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in right to constitute a defense. Each material proposition affirmed by one party and denied by others shall form the subject of a distinct issue. My lord, what I want to contend, that whenever a plaintiff is instituted, then my lord, the other side has an opportunity to deny the proposition of facts a material fact which is pleaded in the complaint. Now the question is, Malad, when there was no denial to that effect, Malad. Where is the question for framing of an issue? They themselves have Malad contested the entire proceeding, entire suit, everything, Malad, on the pretext that it is an ancestral property. And Malad, the clear Malad, the contention of both the sides of the ship was that under 2005 Act, when it was introduced by the Parliament, the daughters become the co-partners since their birth. In the facts and circumstances of in this particular case, keeping view that there is a gift deed on record, there is a relinquishment deed also on record, whether such benefits of as per the ratio laid down by the Vinita Sharma can be given, can be extended to these daughters or not. This was actually the issue on which both the parties have addressed. Now, Malad, at this stage, when Malad, at the second appellate stage, again, there are two Malad, concurrent findings of fact in this particular case. I was plaintiff Malad before the trial. Malad, the suit was decreed. They have preferred appeal has been dismissed. Finding of the learned trial court has been found. Now the question is, Malad, at the second appellate stage, whether Malad, this issue without having a foundational fact can be raised. That is the first point I would like to add. Second, Malad, when the at all issue was not that it is a self-acquired property, Malad, then Malad, the way they want to challenge Malad, it is not permissible at this stage. And second aspect is that Malad, what my learned friend was arguing.
The entire genealogical table which has been projected by the plaintiff
Yes.
is only 3 generations.
Yes.
Only 3 generations
It,
in the plaintiff.
Your Lordship,
We are given the entire genealogical table which consists of only, it starts from Babulal and ends at these children. That is it. This is the genealogical table as per your plaintiff. Only 3 generations.
many things has to be taken into
Yes,
consideration.
this
Not only
will-
Babulal. Your Lordship may kindly
You
see.
just have a look at the plaint.
I
What
am
genealogy
reading
have you given?
the genealogy of the plant itself.
Yes.
Lord may
Page number
kindly see.
2.
Babulal, the first one, that. Then your Lordship will find Surya Narayan Bose.
That's right.
Then my Lord, wife Ahilya Devi also.
Yes.
Mother was also
Ahilya
alive.
Devi ko kuch pata nahi, she died.
Mother, very later on that.
Whenever she died, it's irrelevant.
Yes.
That's irrelevant.
And apart from that, parties are not disputing that the property is of Babulal Ghosh. It is not in dispute.
If the property is of Babulal Ghosh,
Mine.
then under such circumstances, how will Babulal Ghosh form a co-pastory with his son?
That is to be questioned. I will show, my Lord, there is no bar in the law that there cannot be a co-pastory between a father and a son. I will show those judgments. There can be a co-pastory between a father and a son also.
Provided the property
and-
is an
and-
ancestral property.
It is admittedly an ancestral.
How do you say admittedly? Show us
Yeah.
that you say that it is an ancestral property.
Yes.
Unless you make a statement
Yeah,
that it is an
I will
ancestral
show-
property,
I will
there is
show-
no question of admission.
I am showing it. And
No, in the plaint.
Yes.
Show me from the plaint
Yes.
that you say that it is an ancestral property
I am saying.
standing in the name of such and such person and thereafter it devolved upon Babulal. Where is that ever been in the plaint?
Paraman.
I am in Paramount.
Plaintiff and defendants are the full sisters and daughters and members of joint Hindu school with Akshara family in business and property. The genealogical table will the relationship in between the plaintiff and defendants. These are the genealogical. Now plaintiff and defendants own and possess jointly moving property after inheriting the same since the death of their grandfather, father and mother. All occurred after 1956 and the said properties are hereafter called the suit property described in the foot of this plaint. I have very specifically mentioned that it is the property of grandfather. Now, my Lord, may kindly see, in the year 1994, the defendant 1 to 4 cunningly took plaintiff and defendant number 5 to 6 false confidence and tendered their signature over a registered deed of relinquishment under the schedule of property.
I'm looking at the statement made in the plaint that this is an ancestral property
Now
devolved
let us
upon
see
the
their
father.
let us see their written statement.
Why should we see the written statement? We are seeing at the plaint. What is the case of the plaintiff?
Plaintiff's case, Your Lordship.
Plaintiff case is that it was property of grandfather and it devolved upon his son and the n number of children.
Mother, sons, everybody, and including us also.
So therefore, does the property form a co-custody property amongst Babulal, Suryanarayan Ghosh and their children?
My Lord, my country. When Babu Lal died, at the relevant point of time, Suryanarayan Ghosh was already alive. He was alive. He was born in the family. So, my Lord, at the relevant point of time also, I will show, my Lord, certain judgments also. There is no bar in the law that the property cannot.
Please show me that the property acquired by grandfather upon his death or while he is alive forms a co-custody between the grandfather and the son.
I will show. That's why
इतना दिखा दीजिएगा तब हम इनका केस डिस्कस
हम इनको दिखाएंगे इसके अलावा भी बहुत कुछ दिखाएंगे ऐसा नहीं I am not interested in whether her case should be dismissed or not. I am inclined.
Mr. Sharma, जो उस केस में आप इतना बहस किए थे, ठीक है, उसमें बहुत समय लगा के उस जजमेंट
नहीं इसमें भी हम करेंगे
और बहुत समझ के किए
नहीं हम इसमें भी
इसीलिए आपसे पूछ रहे हैं कि उसको सुप्रीम कोर्ट गया कि नहीं गया, आपको जवाब नहीं दे रहे। सर्टिफाइड कॉपी तो आपको जिताए थे कि हराए थे हमको तो पता नहीं, आप हारे थे तो सर्टिफाइड कॉपी आपसे लेके गया होगा ना सुप्रीम कोर्ट जाने के लिए। आपसे बिना बात किए कोई लिटिगेंट सिविल केस में कैसे सुप्रीम कोर्ट चला जाएगा?
इस केस में हम भी मतलब I was also counsel, but मतलब main counsel was somebody else. वो भी इसमें उनसे पूछेंगे. I am not sure. I was engaged.
इससे 3 जनरेशन का कहानी है, so you cannot say it is something which is not born out of it.
But not, I will never argue a point which is beyond.
Yes.
And apart from that, my learned friend has already been a judicial officer. So he might say is also
I don't bother about whoever she has been.
He is equally well equipped in law. I agree.
She has never been a judicial officer. From where do you get this?
No, I'm a lawyer.
She has been a lawyer throughout.
Perhaps
She has
then
never
I
been a judicial.
then I am an extremist.
Her sister Seema Lal.
Seema Sinha.
Seema Sinha.
I was mistaken.
और ये तो इनका स्टैंड है, आप लोग का क्या स्टैंड है? whom are you
ये सब
representing?
सबका एक ही.
You are all
All are sisters.
same board?
All are sisters.
Okay, so all your
Majority-
entire
majority
arguments
we
will
are-
be advanced by one counsel?
कुछ एक्ट बोलता हो जाएगा तो हम एक्ट कर देंगे.
अच्छा, ठीक है, रिपीट मत करिएगा।
Repeat
जो
नहीं।
कुछ छूट जाएगा तो ऐड कर दीजिएगा। ये बहुत इम्पोर्टेंट क्वेश्चन है।
pertinent है.
प्लेट में बाबूलाल, सूर्यनारायण और उनके बच्चे और कोई चौथा जनरेशन का कोई कहानी ही नहीं है, राइट? Therefore, this property, whether it will be
Ancestor
it will form a part of co-custody property or not. Ancestor मतलब co-custody. Whether it will pass on by inheritance or it will pass on by succession is something which is to be seen so far as this. And then you, what do you have to say on limitation?
Limitation I will argue, Lord, and I will show that, my Lord, even if my Lord get considered that whether this deed comes under the purview of whatever, then even then, my Lord, that is within time.
So the property, the gift deed having been executed in favor of the sons, what is the date of knowledge of the
Yes.
sisters?
That I have
There has to be a specific date of knowledge.
Yes, yes.
What is the date of knowledge?
But what has
That would
happened?
be 1994 only. In the relinquishment deed only it
They
is
mention
mentioned.
about the gift deed.
Yes, they
It
mentioned
is
about
mentioned in the gift deed.
Yes, that they said that the father has executed gift deed in
It
their
is
favor.
mentioned.
Yes, yes.
What has happened, my Lord, when the suit was instituted, there was the gift deed prayer was not there. Thereafter, my Lord, when certified copy, etc., your Lordship was given to us, then, my Lord, we have amended the prayer.
No, you must have. So let us take it that it will relate back to the date of filing of the suit.
Yeah,
There is no
definitely.
issue on that. We want to know that what is the date of knowledge of the gift deed. as per your claim.
For the first time, the blanking kept, after filing of the WS.
No, Your Lordship.
Is it mentioned in the relinquishment deed or not?
Gift.
You just show me, madam, where is it mentioned in the relinquishment deed that there was a gift deed in connection with this property?
That is what they said, that they misrepresented that the gift deed executed in their favor. They wanted the relinquishment of that portion of land only.
That was a case of a clear misrepresentation. That's
No,
what is the ground.
Misrepresentation there.
And it has been mentioned, पैतृक संपत्ति.
पैतृक संपत्ति मेंशन करने से थोड़ी होगा. आज तक हम लोग को समझ नहीं आ रहा कौन सा पैतृक संपत्ति. लिखने वाले को समझ आ रहा है.
जो
It
लिखे
is absolutely a technical word.
उनको तो समझ.
I am sure many of the advocates and many of us also might not be knowing, those who have not dealt with in civil law, that what is the minor, fine distinction between these and how the co-custody is formed. So you cannot say it in the deed it is mentioned as sister को was estoppel लगा देंगे.
लेकिन जो लिखता है तो कम से कम समझता है, ऐसा मान के चलते हैं.
नहीं ऐसा नहीं.
अच्छा, और भी अगर लिखवाने वाले भी हैं खुद भी नहीं समझे.
May kindly come to plate at page number 3, para 4, Your Lordship.
Yes.
Before that also, I will read from para 3 that in the year 1994, defendant number 1 to 4 currently took the plaintiff and defendant number 5 and 6 in confidence and caused to tender their signature over a registered deed of relinquishment against schedule of properties by deed number so and so, making them understand that properties described are the gifted properties by their father to sons only, and the properties left in the. So they were aware of this.
तो कहानी आप लिख रहे हैं.
And in the cancellation deed also.
The reason for cancellation is also mentioned.
वर्ड यूज कर रहे हैं, इनके पास नहीं.
Cancellation deed है.
Cancellation
deed कब execute हुआ? What is the date of execution of
That is on 94 only. 94 September.
उसमें है gift deed का कहानी.
Yes, because of
ये बात हमने के हम लोगों के प्लेंट में है कि हमको एक्चुअल में दादाजी वाला प्रॉपर्टी चाहते थे देना, लिखवा लिए दूसरा.
ठीक है. आप हमें ये बताइए. Just a moment. In the cancellation deed of the year 1994, did you mention about the gift deed? Cancellation deed exhibit.
ये सभी कंसीडरेशन ट्रायल कोर्ट का भी है, हाई कोर्ट का भी है, दोनों का भी है.
Let us see. What is the deed of cancellation?
yes.
Exhibit 3 by E perhaps. है तो इसमें लिखा हुआ.
Yes.
You acknowledge? You acknowledge here that there was gift deed. और ये नहीं बोलिएगा ये भी जबरदस्ती लिखा लिया. ये तो आपका कॉन्शियस एक्ट है ना. And you are citing reasons also for cancellation.
And in their deposition also they have said that they were aware of.
नवाजी नामा दलील में तो है
ना. ये 2000 ये कब का है? 1994
September. Yes, that is 14 September 94.
94
only.
14 September 94.
Yes.
You get it cancelled.
जो नवाजी नामा डेट में जो है लिखा हुआ वो हम लोग कहेंगे तो पढ़.
ना इसी में तो है लिखा हुआ. पहला ही सेंटेंस पे विदित हो कि मेरे पिता श्री सचिन सच मेरे सहोदर भाई विजय कुमार घोष को एवं जिसको दान पत्र लिख दिए. फर्स्ट पेज. Cancellation deed का फर्स्ट पेज. Knowledge on that day you cannot deny.
Cancellation deed.
Exhibit 3 by E. वो क्या हुआ ना कि वो नया एक्ट आ गया ना तो थोड़ा सा ऐसा ही लग रहा आपको. सोचा कि कुछ ट्राई मांगा. ऐसा लग रहा.
Three sisters only the.
सूट कभी कभी हो. आप जरा कैंसिलेशन डीड का डेट आप देखिए. उस दिन का तो नॉलेज आप डिनाई नहीं कर सकते ना.
कैंसिलेशन डेट के बारे में तो हमारा कहना ही है. तो कैंसिलेशन डेट तो हम जैसे हमको लिखवा लिए तो कैंसिल कर दी।
That's
Cancel.
good. Cancel किए, लेकिन आपको पता है ना on the date of cancellation
हाँ
that this particular deed has been executed.
नहीं तो नबादीनामा कैंसिलेशन के लिए तो हम गए ना जो
नहीं, उसमें लिखा हुआ है that this property has been gifted.
नहीं तो ये चीज तो यही तो केस है कि हमको ये कहे थे कि आपको हम लोग दादाजी वाला देंगे और अब टोटली
तो हमारा ये जानना चाहते हैं
हाँ।
कि ये जो deed of relinquishment है,
हाँ।
deed of cancellation है,
हाँ।
and deed of gift,
हाँ
whether the challenge to these documents, these registered documents, is barred by limitation of.
हाँ हम आर्गू करेंगे उस पर और ट्रायल कोर्ट ने भी इस पर लिखा है, अपील कोर्ट ने भी लिखा है और दोनों कोर्ट का जजमेंट है मालूम है।
हाँ,
हम दिखाएंगे
इतना आसान नहीं है दिखा पाना। On the face of this
हम
cancellation.
दिखाएंगे
कल दिखाएंगे। कल ही दिखाएंगे ना?
कल
10:30 बजे सुनेंगे आप।
2:15 में रखा जाए।
नहीं, 2:15 में नहीं रख सकते। हम लोग का ये हियरिंग मैटर्स देखिए एक मैटर टेकअप होता है पूरा दिन निकल जाता है। 2:15 में नहीं रखेंगे। The arguments have remained inconclusive. Court found further arguments to be made. 10:30 as first case. और तो कोई नहीं रखे ना first case?
नहीं
उनके written submissions के जितने भी documents हैं ना, सबका इससे पढ़ाता ही नहीं आ रहा। ठीक है?
हमारा क्लियर केस है कि हम एंसेस्ट्रल प्रॉपर्टी इन्होंने डिनाई की। अब आ जाएगा सेकंड एपिलेट स्टेज पर इसको कैसे डिनाई करेंगे?
आपका क्लियर केस नहीं है कि एंसेस्ट्रल प्रॉपर्टी है।
हमारा इनका रिटन स्टेटमेंट के ऊपर
रिटन स्टेटमेंट से कैसे डिसाइड होगा कि आपका
नहीं
clear case
हमारा
है?
तो कहना है कि
आपका
जॉइंट फैमिली
wait,
प्रॉपर्टी है।
just a moment, जॉइंट फैमिली प्रॉपर्टी तो होगा ही, लेकिन एंसेस्ट्रल प्रॉपर्टी नहीं बन जाएगा, कोपास्टरी प्रॉपर्टी नहीं बन जाएगा। जॉइंट फैमिली प्रॉपर्टी और कोपास्टरी प्रॉपर्टी में अंतर है, फर्क है ना। जॉइंट फैमिली तो होगा, इट इज अ जॉइंट फैमिली प्रॉपर्टी, देयर इज अ जॉइंट फैमिली, but by virtue of being a joint family property, it does not become a co-custody property.
I do agree.
इतना पढ़ाई के आप कंक्लूड कैसे करें?
लेकिन जो आपका इस पर्टिकुलर केस का जो फैक्ट्स
हाँ, इस
और उस पर्टिकुलर केस का फैक्ट्स
केस हम लोग इसी पर्टिकुलर केस पे डिसाइड करें। वो एक जजमेंट हम लोग किए हैं, आप चाहे तो देख सकते हैं, यू कैन हैव अ लुक। वो वही तो केस नंबर दिए हैं, पता नहीं क्या केस नंबर है, बता दीजिए।
सेकंड अपील 402 of 2016 402 of 2016 सेकंड अपील।
इससे पहले चेक करेंगे अभी भी क्या है कि नहीं।
उस केस को भी हम डिस्टिंग्विश करें।
हाँ हाँ जरूर।
Correct.
वो आपका ड्यूटी है डिस्टिंग्विश करना। ठीक है। कुछ ऑर्डर्स मैं 10:30 है tomorrow. Do you have the soft copy of your notes? If you have any notes, you can also forward me the soft copy. Have you
Soft
prepared
copy,
any
yes,
notes?
I will forward.
You forward.
How-
आपके पास अगर कोई नोट्स है तो आप भी दे दीजिए।
उनका वाला को नहीं
ईमेल आईडी बताइए।
भाई आप दे, इनको दिए हैं, आप ले लीजिए।
अजीब
इनको दिए हैं, दे दिए ना, आपको दिए ना नोट्स, आपको नोट्स मिला है ना, देखिए लिस्ट ऑफ डेट्स से कोई एरर नहीं है।
नहीं हम अपना रिटर्न
हाँ, जरूर।
सबमिट करेंगे।
नहीं, आप कल भी दे सकते हैं,
बस
ऐसी बात
बस
नहीं। बहस के बाद नहीं समझ, बहस के बाद कल हम लिखाएंगे, इसीलिए उसके बाद आपको मौका नहीं मिलेगा। अगर आपको कुछ बोलना है स्पेसिफिकली तो आप काइंडली नोट बना के ले आइए, क्योंकि कल ही हम लिखाएंगे।
ठीक।
अब सुन लिए हैं, फैक्ट्स बहुत क्लियर है, तो टेक्निकल पॉइंट है, वी विल सी व्हाट इज
ठीक।
Under heading for orders with effect item 10 second appeal 346 of 2019
डिफेक्टिव।
yes sir
Your counsel has got it. आप अपने फोन से लीजिए मिस्टर शर्मा से.
We are for respondent number 6, Your Lordship.
You will get it. वहाँ से ले लीजिए.
Appearance will be.
Mr. Sharma, can't you provide him a copy of the written submissions to your all co-counsels? देखिए ऐसे नंबर 346 of 2019, as per the office note, in spite of necessary corrections in the certified copy of the judgment and decree involved in the present case, the necessary corrections in the memo of appeal is required. Counsel for the appellant is directed to remove the surviving defect or to file an appropriate petition in connection with the defect in memo of appeal as pointed out by the office. Great. ये हो जाएगा. Leave will be done by 3rd of April. Preemptory order. Since the counsel for the appellant is absent, a soft copy of this order will be forwarded to the counsel for compliance. If the defect is removed within the stipulated time, office is directed to carry out further stamp reporting and place the case on the 10th of April.
Item 11, second appeal 383 of 2019.
Your Lordship, I pray for 3 weeks time to remove the defect. You have to just carry out the necessary corrections in the memo. It will be 3 weeks time for that in a matter of 2019. Yes, the record was sent down to make correction. So, 3 weeks time to
Same order कर दीजिए. ना preemptory time till 3rd of February. If the defects are removed within time, post on 10th of February.
Item 12, second appeal 80 of 2024.
May be defective.
Yes, sir.
SC number 80 of 2024. The appeal is defective. For want of court fees of rupees 3124. Counsel for the appellant is directed to take is granted वही same order करेंगे. इससे आगे वाला order नहीं रहेगा, कोर्ट फीस है ना, आगे वाला order.
Item 13, first appeal 111996 of 2024, filing number.
This relates to payment of what has been paid in the trial court. Now it is reported that excess amount is required to be paid.
What was the date of institution of the suit?
The suit was instituted on 8/9/2022.
8/9/2022.
2022.
When was the amendment effective?
The amendment came as in 2023 on 23rd November 2023.
23,
11/2023.
2023. No, the notification is 22nd of February 2020.
Yes, but there is another amendment which were not in our notice. The stamp report has given that notification. That notification. So that
The
case,
suit was instituted after the amendment.
yes, it appears.
Then,
The suit was filed on 8/9/2020.
and this notification is of February 2020.
So
So you pay the court fees.
therefore, so the court fee, yes, the court fee which I have paid in the trial court, that I have to pay.
No. We will not decide the court fees. We will not be guided in first appeal by the trial court. You pay ad valorem court fees. You are required to pay ad valorem court fees. The trial court has committed a mistake. We will also
Yes,
commit
yes.
a mistake.
Then some time may be allowed to examine this.
No, no. You see, your submission is especially incorrect. I do not know in the other case what submission you have made.
No,
Where
no.
is that order in the other case?
That order is within
दिखाइए सर उसमें कौन सा डेट लिखा है यहाँ पर I will recall it
yes, if it is wrong.
if it is wrong. Something.
Ladies have every right jurisdiction to recall the order.
लिखिए FA number,
So
filing number
my
is
submission would be
996 of 2024.
let me examine whether that
Rejected. लिखिए RA number 15991 of 2025 has been filed. Stating that the suit was valued at rupees 33,01,000 and the suit value and the and it is submitted by the learned counsel for the appellant that before the learned trial court, the plaintiff has paid ad valorem court fees of rupees 89,510. He has further submitted that the amendment in Court Fees Act by Amendment Act 2022 came into force with effect on 23/11/2023. The council submits that under such circumstances only fixed court fees of rupees 50,000 was payable.
Not fixed, but maximum.
A maximum court fees of 50,000 was payable, which was applicable prior to the amendment in the year 2022. The Learned Council has also submitted that without prejudice to the aforesaid submission, since before the Learned Trial Court, the appellant had paid court fees of rupees
89,510.
89,510. Therefore, at best, this amount is payable before the first applicant. The office has given the calculation of the court fees payable in the report and has also placed the notification, the Gazette notification dated 22nd February 2022, by which the court fees was enhanced, and the Gazette notification itself revealed that the same comes into effect from the date of Gazette notification. In such circumstances, the argument of the Learned Council for the appellant that the Court Fees Act was amended with effect from 23/11/2023 has no basis. Accordingly, the argument that maximum court fees which was prevalent prior to the Amendment Act 2022 is payable is hereby rejected. Further, the argument that only 89,510 as calculated by the Office of Learned Trial Court is payable is also rejected in view of the fact that this court is not bound by the calculation made by the trial court with respect to payment of court fees. The detailed calculation has already been furnished by the office, and our court fees has been found short by rupees 1,39,260. IA is rejected. The counsel for the appellant is directed to
8 weeks time.
furnish the इतना लंबा टाइम आपको नहीं दे सकते.
Huge amount.
ह्यूज कोई ह्यूज नहीं है. The deficit court fees be deposited latest by 11th of February 2023. If the court fees is deposited within the stipulated time, office is directed to place this case under
I'm
arbitration
making it
heading
with some more
on
time.
18th of February.
Some more time. Some more time.
No time.
Item 14, first appeal 1056 of 2025. ID number.
Yes.
Yes, ma'am, very last order, the report was called for from the Learned Trial Court below. Whether the award or any decree is prepared or not, I have perused the record. From the record, it appears that after the order of this honorable court, on 5/1/26, an award is prepared by the court.
By the award.
Then I have
Certified copy.
then I have to obtain it from there. Just today I came to
Filing
know.
number FA 1056 of 2025. Counsel for the appellant has submitted that the award has been prepared by the Learned Court during the pendency of this appeal. He submits that some time be given to furnish the certified copy of the award. The Learned Counsel has also submitted that IA number 16451 of 2022 seeking ignoring the defect has become infructuous.
Certainly.
IA number such and such is dismissed as infructuous. The counsel for the appellant is directed to file the certified copy of the award with authentication fee?
Yes, certainly.
With authentication fee by 11th of February 26 entry. If the defect is removed within time,
There was no
office is
thought.
directed to carry out the further stamp reporting and place this case on 18th of February.
थोड़ा और टाइम दिया
On
था
the time they certified.
ठीक है मैं अप्लाई करते हैं
बन गया तुरंत ही मिल गया.
Item 15, second appeal 9.22.07 of 2025.
ये भी डिफेक्टिव.
Yes, last.
आपका केस है ये?
हाँ
बताइए क्या डिफेक्ट है इसमें?
इसमें on last date the decree was sent down and relating to court fee I have deposited. एक डिफेक्ट है कि appellant number 1D and 2 to the decree under appeal have not been made party in this second appeal. For that I have filed one IA. What happened you will see that the appellant number 2 to the decree under appeal who was mother of the instant appellant died on 16/5/2018 and appellant number 1D is also sister. She has also died 15/6/2021. appellant number 2 का तो वारिसान हम ही लोग हैं और उनके वारिसान हैं और जहाँ तक appellant number 1D का है तो हमने का ये डाला है पारा 9 में कि उनके वारिसान को पार्टी बनाया जाए ऑर्डर 110 में.
They expired during the pendency of the appeal.
हाँ yes. Pendency of civil appeal.
They were the appellant or you were the appellant?
No, appellant not.
You were the appellant or they were the appellant?
I was also appellant along with them.
Along with them.
Yeah, no.
तो आप क्यों नहीं स्टेप लिए?
Due to inheritance of नहीं हुआ. गीता देवी मरी हैं तो गीता देवी को वारिसान था. I am already one of the legal heirs. और बाकी अदर लीगल heirs भी उनके पार्टी हैं इस अपील में. जहाँ तक so far appellant number 1D है उनका नहीं बन पाया था. इसलिए गीता देवी के अगेंस्ट में तो कोई एक्सपंज में
तो किसका डेथ हुआ था? गीता देवी का.
गीता देवी जो appellant number 1 no appellant number 2 to the decree under appeal है.
ओके ठीक है. तो ये कब डेथ हुआ था इनका?
इनका डेथ हुआ था 16/5/2018.
16/5/18. इसके अलावा किसका डेथ हुआ था?
इसके अलावा डेथ हुआ है बबली देवी 1D.
बबली देवी. इनका कब डेथ हुआ?
इनका हुआ है during COVID 15/6/2021.
15/6/2021. अब इनके सब्स्टिट्यूशन में तो लीगल ईयर्स आर ऑलरेडी ऑन रिकॉर्ड.
गीता देवी के तो ऑलरेडी ऑन रिकॉर्ड है और ये भी बबली देवी भी हमारे बहन है.
सिस्टर है ना? तो
हाँ,
शी इज आल्सो ऑन रिकॉर्ड.
हाँ.
तो ये लीगल ईयर्स का क्या नाम दे रही हैं?
हाँ तो बबली के लीगल एयर्स कुंदन कुमार साहू हस्बैंड है बबली के. आई दोनों बच्चियां हैं बबली. भाई के द्वारा स्टेट रिप्रेजेंट हो रहा था क्योंकि ऑर्डिनरी वन सुरेंद्र प्रसाद शाह एंड गीता देवी. सुरेंद्र प्रसाद शाह के मरने के बाद ये लोग पार्टी
The
में
learned counsel for the appellant has submitted that Surendra Prasad Saw was the Surendra Prasad Saw and Geeta Devi
हाँ ये गीता
were the original plaintiff.
यस.
And Surendra Prasad Saw died, and consequently he was substituted by his 4 children, including Babli Devi, as one within bracket D. And Geeta Devi is wife of Surendra Prasad Saw. He submits that Geeta Devi expired on 16/5/18 and Babli Devi expired on 15/6/2021. But they were not substituted at the first appellate stage, although the judgment was passed on 22nd of May 2025. The learned counsel has submitted that he has filed a petition for addition of party to IA number 802 of 2026. so far as Rita Devi is concerned, he submits that the legal years are already on record.
Already on record.
And so far as Babli Devi is concerned, her legal years have been mentioned in paragraph 9 of the interlocutory application. Let notice be issued to the proposed legal years of Babli Devi, whose details have been mentioned in paragraph 9 of the interlocutory application. To the concerned police station, for which requisite be filed within a period of 1 week. The consequence of non-substitution of Babli Devi at the appellate stage, Babli Devi and Geeta Devi at the appellate stage will be considered upon appearance of the post on 11th of March.